allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. I mean, this county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth about it?
It's not easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the contract.
Nobody's asking you to admit to anything. I just need to make sure you understand the charge.
I'm a proud citizen, sir.
I'm shocked.
UCC folks.
Oh, UCC? Oh, I love it. A sovereign.
The first courtroom encounter takes place in Florida, where Mr. Fox appears on charges involving alleged possession of methamphetamine, alleged possession of drug paraphernalia, and operating a motor vehicle without a valid driver's license. The judge is simply trying to establish whether Fox understands the charges against him. Rather than giving a straightforward answer, Fox repeatedly challenges the wording of the allegations and attempts to redirect the conversation. Eventually, the judge makes clear that understanding the charges does not mean admitting guilt. After several exchanges, Fox finally confirms
5,000 on the meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right to the T.
Mr. Fox, when you sue me, make sure you spell it with 2 N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
He's not asking Fox to confess, explain the evidence, or agree that he committed the alleged offenses. He simply wants confirmation that Fox understands the accusations appearing in the case. Fox initially struggles with that distinction, leading to an increasingly repetitive exchange. The judge emphasizes that the question requires only a yes or no response. Eventually, Fox provides the answer the court needs. The judge then addresses bond and scheduling matters. The exchange demonstrates how courtroom proceedings can quickly become complicated when a defendant refuses to answer.
I was going to go there today, and you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So So I will see you in person at the Bothell Municipal Court at that time. All right.
Looks like there's no free will then.
So,
So then what am I doing here then? Hold on. What am I doing here?
well, right now you are not responding to my questions. So
Well,
I'm
you're
going
not
to have you
responding to any of my. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to
Miss-
understand too. I don't understand what's going on. I don't know every.
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448 SM. People versus Eric Martin. Everybody hear me?
Yes, good morning, Judge Donna Sub on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I could adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court? Would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements here, talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything you keep doing. All your little negative comments, things that you want to say about people. You think you're the smartest person in the room.
Moves to Bothell, Washington, where Mr. Carter appears remotely for an arraignment. The judge asks him to confirm his full legal name, explaining that the court needs to establish who is appearing before it. Carter questions why his name matters and suggests that a person could potentially change their name. The judge does not engage in a philosophical debate. Instead, she decides that an in-person arraignment would be more appropriate. She schedules the matter for a future appearance and explains that Carter will be...
I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I want to state also that if it was recorded, it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like. Or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without
all right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did, well, I don't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
Yes or no? Yes or no? Is he somebody that you think you can get that you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing.
Does not consent to the court proceedings or the scheduled appearance. The judge calmly explains that consent is not what determines whether the court can require him to appear. Carter continues raising questions about legal authority, bonds, and financial instruments. The judge largely avoids debating those theories and focuses on the procedural requirement. He must appear in person for arraignment. Eventually, Carter confirms that he will attend on the scheduled date. The exchange illustrates a recurring courtroom problem. Challenging a court's authority does not necessarily eliminate the court's ability to issue.
That is my name.
Basically, what happens is you were issued one citation. It had 2 violations listed on it, so it became 2 different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those 2 cases, so for each of those violations, you have 3 possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess.
Features Eric Martin, a recurring figure in the source material, appearing for a bond violation hearing. His appointed attorney asks the court for permission to withdraw, explaining that communication with Martin has broken down and that effective representation is no longer possible. The judge grants the request and asks Martin whether he wants another appointed attorney. Martin begins criticizing his former lawyer and discussing his disagreements with counsel. The judge interrupts, warning Martin that continued personal attacks could result in contempt. She makes clear that the courtroom is not a place for insults or person.
$25 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the 2 cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay.
I'm not sure. I'm not sure why you're asking that.
Repeatedly narrows the discussion to one simple question. Does Martin want another court-appointed attorney, want to represent himself, or want to retain private counsel? Martin continues attempting to add commentary about his previous lawyer and various legal arguments. The judge stops him and explains that there are only a few choices available regarding representation. Eventually, Martin agrees to another appointed attorney. The judge then considers whether an attorney who represented Martin in another matter might be suitable. After further discussion, Martin agrees to try working with that attorney again, allowing the court.
When I observed the vehicle that Mr. Roosevelt was driving, I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to he was traveling, and to drive a vehicle, you have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, convenience, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle.
Case takes place in Michigan before Magistrate David Heist. Roosevelt Williams is appearing in connection with two civil infraction cases arising from a single traffic citation. One allegation concerns failure to provide proof of insurance, while the other concerns an expired registration plate. The magistrate carefully explains that Williams has three options for each citation: admit responsibility with an explanation, or deny responsibility and proceed with a hearing. Williams chooses to deny responsibility. The magistrate then explains the allegations, potential financial penalties, and the basic procedure that will govern the hearing.
You're defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
Right, it's a motor vehicle which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
But
well, I see where
I've
this
heard
is
your
going.
argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that this a driver license is not a requirement, that this is you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8, to which
I'll ask you this. Is that right, the right to travel?
that is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is what right has been converted to a privilege?
My right to freely travel unencumbered
very good.
and
Now,
unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate
travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So
okay, so
that is what the law says, and that's what I'm finding. Is there anything else you want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
U.S. 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was Shuttle.
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it says
U.S. 147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So, for instance, when you said 769 Fed Second 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, second edition, at page 1344. So when you're asking me about this